Hello, it's August 2022, and keeping in with the theme of revisiting old topics and my older videos, I'm going to focus this video briefly on flies. I'm going to focus on flies. Hello, it's August 2022, and keeping with the theme of revisiting my older topics and my older videos, I'm briefly going to be talking about something that is still technically pending before the courts in Alberta. Now, with regards to the criminal matter of alleged obstruction of an officer and alleged assaulting an officer. And I'm just going to reiterate that I've shown evidence, independent evidence, why I needed to be convicted of these two charges, because that was their defense for the lawsuit for the permanent disability injuries that they had done on me. So I'm going to do a real quick recap on the events. So in April of 2012, I moved across country to Alberta, and around June 2012, I had first-hand knowledge of the sexual abuse, sex trafficking of vulnerable women at this nonprofit mental health organization, which Alberta Health Services was sponsoring 60% of. And I think it was about a few weeks after that, it could have been like in later July, I was interviewed about, I don't even know what they were interviewing people about, but I ended up telling them what I knew at the time. And it appears that somehow it got leaked out. Fast forwarding to December of 2012, I got dragged into it personally by a false accusation by, we'll call her the female of focus here, because there was others that I guess were involved in this, but this one particular female is the center to the story. And so she falsely accused myself and another male co-worker of some sort of sexual assault. I have no idea what to this day. And so now I'm dragged into it personally. And over the months that followed, I had resigned the month prior. And so I extended my resignation, which would have been my second or third mistake. Anyway, after that, I had left the organization anyway. I spent 4 months meeting with her, always in public, audio recording, not only my vindication, but trying to extract information about this sexual abuse, this sex trafficking. And there's hours and hours and hours of audio, and I've shared big chunks of it in my much older videos. So you can have a listen if you really want to, make sure everything's in context. And then on May 4th, 2013, 2 former police officers who were terminated over all these events decided to do street justice on behalf of the female and to silence me. And this is based on the comments that they were telling me as they were beating me. They approached my vehicle. The one officer, former officer, had sucker punched me through my driver's window, knocking me out. Now, as I was coming to, I guess he was choking me. And he testified to choking me as I was knocked out. And as I was coming to, I guess I grabbed his wrist, when I was becoming conscious again. And I realized I had his wrist because I couldn't breathe. And I've highlighted how it's a natural instinct of any living thing to want to breathe, to clear the obstruction. Now I'm going to interject here. The basis of the allegedly assaulting a police officer stems from when the former officer had grabbed my throat and was choking me that I couldn't breathe while I was unconscious. He testified to this very clearly. And as I was coming to, I grabbed his wrist, I suppose because I couldn't breathe as I was unconscious and I was coming to, and my instincts had kicked in to want to breathe. So I was trying to remove his hand from my throat. And there's photos of his fingerprints around my throat. Now what's interesting is the judge for the trial proper had stated when I had brought this up during the trial that I did not have expert testimony to verify that someone unconscious or coming to semi-conscious is automatically, through automation, would react in that way. The standard now has been raised from a summary offense to an indictable offense. That standard, like, so for example, in a murder trial, there'd be a higher standard of evidence that would be needed. And that trial judge went from a summary offense standard to an indictable standard, which is unprecedented. And the other officer had put a gun to my head, testified that it was a taser, but according to the police records, he didn't sign a taser out that day, so whatever. And then they handcuffed me and beat me, leaving me partly disabled for life. Now, everything had gone sideways for them that evening. When they, whatever reason they thought they were there or what they were doing wasn't accurate. Now they have to do damage control. And the next day, allegedly, they charged me for allegedly assaulting them and allegedly obstructing them. They needed convictions on this for their defense for the lawsuit. Now people have asked, well, why didn't you wait till after? Because the first time I testified wasn't scheduled until the 2-year limitation period to sue was to expired. So basically they wanted to see if I was suing, and probably if I didn't sue, well, who knows, maybe that everything would have been dropped. I don't know. You can only speculate, and I don't deal with speculation. Now anyway, it took them the whole trial for a summary offense, which in the United States is considered a misdemeanor, took 49 months. There's an old case law, R versus Askoff, which I'm trying to remember now off the top of my head. It was like 11 or 12 months to be tried within a reasonable time. Section 11B of the Charter, Canadian Charter of Rights and Freedoms, stating that people have the right to be tried within a reasonable time. And then there was a new case law that came out, R versus Jordan, which was very clear, 18 months. And they were applying that, the Supreme Court ruling on that was applying it retroactively. So 18 months. My trial lasted 49 months. Amazing. Just to put it into perspective, somebody being tried for murder, I believe was like 30 months. So my trial, my case lasted, even for an indictable offense, exceeded that. Now I went through my first 2 lawyers. They were throwing me under the bus. I took over the trial. My PTS, my post-traumatic stress, calmed down enough that, you know, I had no choice to take over my trial. And all my evidence and everything else, and a lot of things being suppressed. There are 4 versions of trial transcripts, with the last one indicating that there are portions omitted by request. And I share an email where the 4th lawyer that I had and 5th Crown prosecutor was asking what was omitted. Do you remember what was said? Everything else. And anyway, so after the conviction, I immediately filed my Queen's Bench appeal. That's the first level of appeal in Alberta. Filed my own materials, and I incorporated the Section 11B charter argument. Now, between the conviction, the judge convicting me and sentencing, there was like 6 months, almost 6 months in between. During that time, I filed an application, a motion for a Section 11B charter argument, because until sentencing, the trial is still active. And basically the trial judge even dismissed the Crown prosecutor, who was agreeing with me, yes, it exceeded the Section 11B, just dismissed us both because they needed a conviction. So when I filed my materials, I had my 3 primary arguments, and then I had all my sub-arguments. And the first one was the Section 11B to be tried within a reasonable time. Now, the first, and I mentioned this just in a recent video, the judge that originally heard the appeal was on my side completely, 100%. And we had to wait 4 months until he was available next so we can continue with the appeal. We had seized him. The Crown prosecutor agreed to it. And at the last minute that morning when the appeal resumed, they switched judges. Now, this judge that took over ignored all my main points. So there's no ruling on it. And she ruled against me in for that level of appeal. So I immediately had filed my Court of Appeal materials. And so I had actually my third lawyer was going to handle that. I figured, hey, I filed my own materials. All my arguments are there. This can't get messed up. But obviously, it can. So the fourth lawyer for the Court of Appeal, basically that was just dismissed, and there's still no ruling on the Section 11B charter argument to be tried within a reasonable time, and my other main points, and even my sub points. Now that I'm thinking about it, now I had some lawyers in my province of origin, Ontario, look into it, and they were we were looking at the Supreme Court of Canada, because everything that the Calgary courts were doing right from the trial proper to both appeals were going totally against the Supreme Court ruling of being tried within a reasonable time. But what ended up happening was the Supreme Court came back and said, well, they can't do anything because there are no rulings, for example, on the Section 11B charter argument to be tried within a reasonable time. They can't rule on something that hasn't been ruled on. So those arguments are still before the Calgary courts in the appeal levels anyway, because the so-called trial judge for the trial proper arbitrarily picked 17 months, just 1 month shy of 18, and just dismissed both the Crown prosecutor and myself. Arbitrary number, just to bring it below the threshold. Now, we gotta stop here because people are going, well, we don't understand. How is it 49 months, but the judge is saying 17? So, to be tried within a reasonable time, I'm just gonna shoot off an example. I'm simplifying this, so, just anyone who has more complex understanding or working knowledge of law, bear with me. I'm just trying to simplify this for everyone. So if you, for example, during trial ask for 10 adjournments, which totals to be 2 years, just making up numbers here, because you were asking for adjournments and everything else, that would be your fault. So anything to delay the trial that's your fault would be deducted, or wouldn't be deducted. So it would be deducted. Anyway, any delays, for example, by the courts, the Crown prosecutor, either directly or, say, for example, police investigations, whatever, that would be in my favor, for example, in the delays. Every single delay was either by the courts, the Crown prosecutor, or the Calgary police. So that's why there's 49 months. And then when you calculate, the Crown prosecutor agreed that the trial exceeded. Okay. We disagreed by how many months, but when you're looking at 49 months, comparing that to 18 months, a few months here and there, we still exceeded it. So the point being that the Supreme Court ruling could not hear my case only because the Queen's Bench Appeal and the Court of Appeal of Alberta didn't make a ruling on my main points, my main arguments. Technically, they're still pending because there's no ruling, although my material is very clear, filed. What would have to happen is I would have to take my case, reopen it. For example, with the courts in Alberta. Now, I'm just going to paint out a scenario here. If I went back to the Court of Appeal of Alberta, they would say, oh, well, you got to get the ruling from the Queen's Bench Appeal. The Queen's Bench Appeal would have to rule on the appeal. For example, with the Section 11B charter argument. Now, the Queen's Bench Appeal can say, no, this has to go back to the trial judge who convicted me. And basically, to get that trial judge to say they made an error. That would never happen, especially with all the corruption that went on with the trial. And that is what I would have been up against. And to go back to the judge and say, hey, you made him, no. And throughout the trial, that was made very clear with one of my voir dires that, yeah, they weren't going to recuse themselves. But anyway, so that would be, say, relying on the Queen's Bench Appeal to make a ruling. So in essence, because there was no ruling made originally with the judge who took over, they would have to basically be saying, oh yeah, I made a mistake. What's the likelihood of that happening? Now, the Court of Appeal for Alberta, they can basically just wash their hands saying, well, yeah, this is all on the Queen's Bench Appeal, and everyone just passes the buck.
So, what happened with your head? You said you fell in the shower or something? Do you remember falling?
No, it happened so fast. I remember I was going in the shower. It happened so fast.
Did you try grabbing onto the shower curtain?
No, because I went straight for the tiles and all my shampoo bottles fell. Yeah,
Now, I want to put this into perspective. We hear about people who have been wrongfully convicted, incarcerated for 10, 20, 30, 40 years. And what had happened, and I'm generalizing here, okay, I'm just trying to make this simple. Somebody had basically, as a descriptive, resurrected someone's case. They reviewed it, said, yes, look, there's some issues here, and brought it back to the original courts. Now, mind you, after 10, 20, 30, 40 years, the people who wrongfully convicted that person, knowingly or possibly mistakenly, they're gone. Like, you know, they've either retired, changed careers, you know, the likelihood of them still being around. And then the new people in those courts, you know, they don't care. There's nothing attached to them. So they just kind of like, okay, yeah, this is wrong. And they get vindicated because the case was resurrected. Now, we only hear about people incarcerated because it's, you know, somebody in prison. I mean, that's traumatic. That's bad. Now, the difference with, say, for example, with my case, although I did serve jail time as a way, I guess you could say, to intimidate me, which I don't think it's worked because I'm still talking, right? I'm out in public, right? But my prison is still, as I said in my older videos, I still have my prison in my mind and my vehicle, and wherever I am, it's my prison. Now, I'm not saying that I'm worse off than somebody who's actually in prison. I'm not saying that at all, but it's still a prison because it's hanging over my head, this injustice. And it doesn't matter how it all began for me, this injustice. For example, with this knowledge of sex trafficking, whistleblowing, all this stuff. I had to deal with what's before the courts. And this is what the aftermath that I'm living in. So ultimately, yes, it began with this sexual abuse, trafficking of these women, and I threw away my whole future in the end. And I never dreamt, like, that wasn't my objective. Could never even have imagined that how my life would have ended up for my efforts, but I had to deal with what was before the courts. So just in a nutshell, my appeal arguments are technically still pending before the courts in Alberta. But you can understand why there'd be no point of me going back, especially, for example, if it went back to the trial judge or the trial proper of the alleged charges. Remembering, I want to segue for a moment, that I was convicted. The trial judge cast doubt 3 times in his conviction, and I was convicted contrary to the Crown Prosecutor's evidence. But say if it did get resurrected and went back before that same judge, he would be in a position to say, oh, you need more jail time. Not that I would actually need it, but as a way to use an explicit FU for challenging. So there's always that potential. So that's all I really want to talk about, was my appeals are still the Section 11B charter, and there's 2 other primary ones, and I have other sub ones laid out nice and clear, never ruled on. And that shows the level of corruption and injustice in the province of Alberta, specifically the Calgary courts, that I would have never, ever thought that they would just blatantly ignore and not even rule on anything. Who would ever thought? I mean, I was getting tastes of a lot of different injustices and seeing the trial transcripts tampered with over the years. But I never thought that, okay, here's my material, it's filed, you can't ignore it. And they did. So take what you will from this, but it just shows people who've never experienced this type of injustice how easy they do it and how blatant they are about it at times. And I just want to highlight that I'm not speaking bad about blanketing every judge, every Crown prosecutor or prosecutor, wherever, all police. I'm not saying that at all.
I think a lot of them are just stone cold, there's no emotion, and they don't view people as people anymore. And you almost feel like you were literally living in the Twilight Zone. And you feel like you're the only sane one in a bunch of insane people. And it's up to the point where I'm afraid that I'm going to start thinking that this is normal. I don't want to ever get to that point. There's good people, but they're outnumbered. 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 I don't understand. Nothing makes sense. Like, something's not right.
Because it's like going in the fucking Twilight Zone. Like, everyone here is okay with this.
Because, as I said, the original Queen's Bench appeal judge, Judge Nixon, was totally on my side. He got replaced with somebody who was on their side, but not because of the evidence. Anyway, that's all I'm going to say. Thank you for watching. Please like, subscribe, comment, and share.